Hello, my name is Karen Einstein, and I'm here with IPNE, the Independent Publishers of New England, and we're on our program Ask the Experts, a program we air every Thursday from 10 to 10:30. It often goes on to 11, and we speak to a number of leaders in the area of independent publishing and in publishing in general. Today, we have two people here with us on the broadcast, and we're very fortunate to have both of them who have a great deal of experience in copyrights and copyright law. The first person that we have with us is Christopher Keneally, and he's with the Copyright Clearance Center, and he also hosts a podcast entitled Beyond the Book at beyondthebook.com. He was previously a journalist and wrote on a wide variety of issues for journals, newspapers like the New York Times and the Boston Globe, and he was a contributing editor to Escape magazine, which he can tell us about a little bit later. He's also the author of a number of different books, primarily on Massachusetts history, which is something which is of total fascination to me. It's an incredible state. Also with us, we are very fortunate to have Virginia Towler, who's one of our members and someone that we're just really lucky to have with us. She's the author of a book entitled Severed, which addresses a number of fascinating contemporary themes, one of which is the issues surrounding copyright, the whole copyright law system. She worked in the Philippines for a number of years after graduating from Georgetown University, and is a practicing attorney who also writes and speaks several languages. She's the recipient of the Screenwriters Fellowship, which was sponsored by the Writers Guild of America. So welcome to Ginny and Chris. First of all, I'd like to ask both of you what some of the major issues and major confusions about copyright law are for a new author or a new publisher. What advice would you give someone who's new to the field?
Well, this is Chris Keneally, and I'm very happy to be able to speak with everyone on the IPNE network, so to speak, and thank you for the invitation. I suppose the most important piece of clarification that we like to give at Copyright Clearance Center is something that's really important in this digital age of ours. We're all accustomed to the way that online and on smartphones and tablets, sharing information, sending copies of photographs and articles and even books and other kinds of files is all very common, and it leads to the impression that information wants to be free. That's a very famous quote from Stuart Brand, who is a figure throughout the history of the development of the Internet. And we may remember him, too, as a publisher. He was the publisher of the Whole Earth catalog. Quite fascinating. Steve Jobs referred to the Whole Earth catalog as the first search engine. Of course, it was a print edition. But what Stuart Brand said was, he said, information wants to be free, and he said information wants to be expensive. He said those two together. And the free part did not mean free as in no charge. What he meant was free as in the sense of the kind of hippie counterculture notion of free. Free as accessible, open, available. And so on the Internet, just as in the bookstores, Copyright Clearance Center believes in respecting the value of intellectual property, that creators, authors, publishers really, they do this certainly for the love of the work and for the desire to share their knowledge, their expertise, their imagination with the world. But they also need an incentive to do this. This is a business, and so the first thing I would clear up is that copyright still remains in force in the digital age. Just because it's so easy to publish and so easy to share doesn't mean that there should be no compensation given to authors, and that's, I think, a very important point, and I'm sure one that will make the members of IPNE very happy to hear.
Yes, thank you very much, Chris. And Ginny, what's been your experience both as an attorney as an author with the entire copyright process?
Well, can you hear me?
Yes.
Oh, excellent.
Sound
Okay.
great. Sound great.
Thanks for inviting me. I'm probably coming from a more, perhaps a little bit more of a negative angle in terms of what copyright does not do.
Okay.
Copyright does not protect your work. It protects people's right to use your work. And, you know, and it's done, like Chris says, in the vein of, you know, everyone should have a wellspring of information from which they can become creative themselves. My problem is when it's done with an ulterior motive of actually stealing. And unfortunately for me, that has been my experience, I'd say over the last 20-something years, as I've tried to publish my writings and get credit for them. So I actually sued someone in district court. In fact, my case is probably one of the few copyright cases that ever went to trial for copyright infringement. Most of them are dismissed or they're settled out of court. Mine was, you know, some time ago, but the point is it's very hard for writers to actually protect their work. And I just wanted to write about my experience so that other writers could be a little bit more aware of what they're doing when they do write and they pass their work to an agent or to a production company or to a creative outlet supposedly there to help them. My contention is they're not necessarily there to help them at all.
Okay. Chris, would you like to comment on that?
Well, that sounds unfortunate, and I'm sorry to hear that.
Thank you.
Okay. And Ginny, I recall that you said that you might be one of the few people that actually brought a case to district court for copyright infringement.
Yes.
And I would imagine that you've spoken with quite a few authors about their experiences. So I was wondering how you discovered that your work had actually been lifted and what sort of infringements had taken place.
Well, this is another thing that I wanted to write about in my novel, but also in warning people. You know, the law is so difficult, and there's so many gray areas, and there's no certainty in it whatsoever. So my contention is that when people steal, if they're smart, they're not going to be so blatant as to take, you know, what you've written verbatim, although it has happened. Most people are much more stealthy in how they do it. In my case, when I had won an award with a fellowship with the Writers Guild of America East Foundation, I wasn't the only winner. There were 11 of us selected. And so this was in the 1990s. It was a big deal for me, at least, because it was the first screenplay I had ever written. Well, because I was an attorney and I had, you know, become one of the fellows, companies were interested in seeing what I had. They wanted to read it. And because I was an attorney, I was my own agent, as it were. So what happened was I was actually in a movie theater. And I saw the work on screen, and it seemed so familiar to me, but I couldn't figure out what it was. And then it dawned on me that the director who had used my work, I had actually sent it to someone believing that it was going to reach him, and I thought, well, he got it, because there it is on screen. And, you know, it was one of those things as an attorney, what do? You know, I had to sue him. How can I not represent myself if I'm purporting to, at the time, represent America as an attorney with the Justice Department? So, so that's it. It's strange. It's a strange thing. I think the theft is so rampant. I don't think it takes too long for people to find their work out there if they search. I wasn't searching, but I know that there are people who actually want to protect writers, and I'd say just find those people like Chris. If you know, there are good people out there. I'm just saying that my experience has been extremely negative. And
Right.
I'm so proud of finally being able to have my say with my own novel, which I self-published on my own, because that's the only way I could truly protect myself, is to self-publish.
I see. Okay. Thank you very much. And very sorry this happened to you, but I have to say I'm glad it happened to someone as competent and knowledgeable and determined as you are,
Thank you.
so that you could actually bring it kind of into the public eye, because I think it is an important problem. But I also take some solace in the fact that it's not a typical problem that's happened to a lot of authors, or at least it's not an obvious problem. And so, Chris, I was wondering, for most new authors or new publishers who are grappling with when to copyright and why to file for a copyright, and the whole issue of what copyrights are, at what stage in the process would you suggest a new author or publisher consider contacting a copyright lawyer and getting help and figuring out what to do?
Okay, well, a couple of things to say. It is true today, and has been since 1989, that copyright is automatic. In the past, before 1989, when the U.S. joined the Berne Convention, which is a treaty that kind of tries to set standards around copyright law for the world. Prior to 1989, you needed to register your copyright with the U.S. Copyright Office to be able to have copyright. Today, copyright is automatic anytime a work is fixed, and so what that can mean is, and I'll hold it up to the camera here, if you can record something on your smartphone, if you make a film, a video I should say, if you do a voice memo, if you send an email or anything of that sort, that is immediately copyrighted to you, the author. However, should you find yourself in the situation, the unfortunate situation that Jenny was in order to go to court in an infringement case, you will need to have registered the copyright. So a couple of things further to say about that. All that information is online at copyright.gov. Which is the website of the U.S. Copyright Office. Copyright Clearance Center, which I believe people are seeing online right now, we are at copyright.com, and there is often confusion between the two, and certainly if someone comes to us, we'll direct them to the Copyright Office, but we do not register copyrights. The U.S. Copyright Office does. Once you have registered the copyright, then you are able, should there be the unfortunate infringement, to take that case to a court. However, as I say, you have copyright automatically once you have fixed the work, and that can mean whether it's in print or whether it's simply a document file on your laptop. Those are equally copyrighted.
Wow, I had no idea. Thank you. And Chris, another quick question for you. What are some of the typical issues that you deal with on a daily basis with authors and publishers?
Oh, well, typical. What I'm fond of saying about copyright is if you're confused, you're beginning to understand the problem.
Brilliant.
Copyright is, it was once upon a time a sleepy corner of the law. Jenny went to law school, so she can tell us about this, but it was possible in the past for someone to attend 3 years of law school, pass the bar, and never have taken a course in copyright law. But certainly today, copyright law is at the forefront of so much of what is going on in the economy, and that really has changed because making copies was once a very expensive and very arduous task. You had to have a printing press. But today, of course, the web, the World Wide Web, is an infinite copying machine. So if you publish material in a blog or on your Facebook page or whatever else you have, that is available in, as I say, infinite copies to anyone who can get online. What this meant, or has meant, is an explosion of creativity, and certainly that is seen in the world of self-publishing. or as perhaps you would prefer to call it, independent publishing. The other joke I like to say is, once upon a time they had B movies, but today they are independent films. And once upon a time,
Watch yourself.
but once upon a time, and this is it's an important point. Once upon a time, and maybe Jenny can talk about this too, self-publishing was not looked upon with great respect. But today, self-publishing is a very important part of the publishing business. Authors of all kinds are able to choose where they can publish, how they can publish. They can work with Amazon, they can work with Smashwords, they can Apple has, of course, a self-publishing service. So there are many different options for them. They do not need to work with a publisher. They can reach their customers, their readers directly. And so that explosion of creativity is really important thing. But what it means is that copyright is really, it's gone from the shadows, gone from the corners, and really kind of moved to the forefront of creativity, and therefore, as it becomes more important to people, there are going to be, unfortunately, misunderstandings. There are going to be lapses in the law. There's going to be all kinds of things that raise concerns for people. What I would say to the listeners is that I'm more of an optimist than a pessimist. I believe that the risk of infringement, the risk of stealing, is there. It certainly exists, and we've heard an example of that. But if we think about it for a moment, the real tremendous opportunity that everyone has today to express themselves, to share their imagination, to share their expertise, this is so important, and is something I wouldn't want to see people hold back because they're afraid that that their work may be stolen. I mean, I can tell you that it's just as it is with plagiarism. It's easier today than ever to plagiarize, but it's also easier than ever to catch someone at it, and we have seen examples of that. And I believe that there's a balance there.
Okay, well, thank you very much. And Ginny, any comments or questions for Chris?
No questions. It's a comment to echo what Chris said, notwithstanding the negative experience that I've had. I encourage people to create, but I guess what I'm advising is that they do it themselves. And that's why IPNE is such a big deal for me. Because it gave me an outlet to be my own boss with contacts of people who have gone ahead of me, who've already experienced things, people I can learn from. I think too often, because of the need for fame in our country, everyone's thinking, how can I write this bestseller? How can I be in the New York Times bestseller list? They think, how can I get the best agent in the world? I was one of them also. I was going to big companies, maybe not, California ICM or CAA or any companies like that, but I was going to agencies in New York, and I had some gravitas behind me, as an attorney with the Justice Department, and so I was able to get in the door, you might say. But the reality is, a lot of those companies are not really interested in first-time writers. Even J.K. Rowling, how many people? How many companies now wish they had paid attention to her? Half the time they're looking for the hit that's already been created. So half the time when they're looking at your work, they're not necessarily looking at it to take a gamble on you. They're just seeing what's out there. So I guess what I'm saying is, I'm an optimist now that I'm a self-publisher. I feel the world has opened up for me. I know I have a lot to do, but I think I'd be doing that work anyway if I had an agent. So what I'm encouraging people to do is, don't waste your time trying to get Hollywood's attention. Don't waste your time trying to send your work out to other agents who are just going to sit on it. So as pessimistic as I am, as a lawyer, and I think that's how lawyers are bred. I'm still very, very excited at the fact that my novel is published. I'm 100% proud of it. No one told me what to do. I hired excellent people to assist me. And I guess that's what I encourage people to do. Quit waiting to be validated by a third party. Validate yourself.
Yes, good point. Very good point. Very difficult to do, but a very good point.
Well, I was just going to say, you mentioned being a pessimist by nature as a lawyer. I should add that, of course, my name gives it away, but I'm Irish background, and so the Irish tend to be pessimistic as well. They come from a country where it's either raining or it's going to rain, and so
Right.
that sort of shapes their frame of mind. And it is. I was just thinking about copyright, though, because we were talking about how easy it is, unfortunately, to sometimes obtain material that's not yours, and to reuse things. Another thing I would mention to publishers, to authors listening, is that when it comes to reusing work that we find online, so for example, if you're thinking about making a cover for your, an illustration for your book, and you find online an image, let's say, of a postcard or a photograph, really, anything like that. And you think, oh, that would be absolutely perfect for the cover for my book. Of course, you can't just download the picture or the image and then print it up in 500 copies or put it online as part of your ebook or anything like that. You need to seek permission for its reuse. That can be a difficult process, particularly with images. Seeking permission, so you may be, for example, as a publisher, thinking about creating an anthology of work, and so in your research you have come up with a variety of, I'm just making this up, short stories or newspaper articles or something, all on a single topic, golfing in wintertime. And it would be a very slim book, I suppose, but let's just imagine. Although, just as a sideline, two very famous writers, Rudyard Kipling and I'm blanking, the author of Sherlock Holmes. Why can't I think of the...
Arthur Conan Doyle.
Conan Doyle.
Arthur Conan Doyle, thank you for that. Rudyard Kipling had a home in Vermont, down near the southern part of Vermont, near Brattleboro. And Arthur Conan Doyle came to visit him, and it was during the wintertime. And the two of them got sort of cabin fever, I suppose, and decided that they wanted to play some golf. So they invented this whole idea of winter golf. Check it out; it's a wonderful story. But let's say you're putting that anthology together. You would be, you would see all these various articles and short stories and so forth. You would be required to get permission for each of those. Some of them maybe, perhaps it was something that Kipling wrote in 1895. Well, that would be in the public domain, and you would have you would be able to use that without permission. Okay. However, you might find another short story that had been published in 1985, not 1895, but 1985. And let's say it was Ginny. You would have to go to her to get permission to reuse that that particular short story. With text, it's often much easier because there's a name attached to it. There's often a copyright sign that says copyright Arthur Conan Doyle or copyright Ginny Towler or whoever. But with images, graphs, illustrations, photographs, the identifying material is often absent, and so it really becomes all but impossible. So a note of caution to people who are publishing. Just because you find an image online, just because there's no immediately obvious identification as to the owner, that doesn't mean it's free to use. That's not in the public domain, even if it's publicly available. And you could find yourself in an unfortunate situation where you had reused that material without permission, and the copyright holder could emerge and prevent you from distributing your book if you had printed it, or require you to stop distributing the ebook online, anything like that. So I would particularly caution people when they find material online to seek out and obtain permission. And unfortunately, trying to do that for a week and then giving up doesn't mean you can use the material. You really should have to go find an alternative.
Okay. Chris, a number of members have been writing in with questions, and one of them is, does the publisher have to register with the CCC in order to have it turn up on the site search?
On Copyright Clearance Center's website, copyright.com, yes, you need to have your work, and I prefer to call it listed rather than registered, so that we don't have any confusion. Registration for copyright is with the U.S. Copyright Office, as I was mentioning. And so listing your work in our catalog does require you sign up with our services. If anyone would like to do that, they can email me simply at chrisk, C-H-R-I-S-K, at copyright.com, and I will be sure that someone from our rights holder relations group is in touch with them. It's very simple. We do not charge you to list the work at all. There's no fee involved. And if the work is then, if someone comes online and seeks permission for it, we handle that transaction for you any time of day or night, and then reimburse you with the royalty. As an agent, we have a charge that varies, but is very typical to agents in that case, around 15 to 20%.
Right. Okay, thank you. And Ginny, a question for you. Did you have your manuscript copyrighted when you sent it to the agent? So is it already copyrighted?
Absolutely.
Okay.
I was, I don't even know how to describe how paranoid I was about protecting my copyright. When I gave it to people, I had them sign something saying that they read it. I tried to trace everything. The reality is, if your work is good, it's going to get stolen. That's the reality.
Okay.
Yeah. And I'm not saying my work was all that great. I just think I have a unique perspective, and it was something that people hadn't read before, and they liked it enough to lift it. I did everything to protect my copyright.
Okay. Okay.
Sure.
And Chris, following on from what Ginny was just talking about, are there any tools for detecting if someone has actually violated your copyright?
Not specifically. I suppose the web is the biggest tool to do that, right? You could just sort of search for your name or search for the title or something like that, I suppose. But as far as I know, there is nothing available that sort of hunts things down.
Okay. And yesterday we were in a fascinating discussion with Ginny where a number of points came up, which I'd love to hear comments on. They're a conversation that could have gone on for days. We were talking about the hubris of thieves and the reason why people do actually steal, and what, if there's anything that can be done with that or how to deal with that. And then also the difference between copyrighting an idea and the expression of the idea, because it seems that the expression of the idea, if you have an idea for a novel, it might be brilliant and fantastic, but the real work is writing it and getting it through the editor and dealing with the illustrator and the proofreaders and the printers and all of those types of issues, which is more kind of what I was considering copyright for, is the work that you put into it instead of just the idea. Although I do realize that they are both important. And in that context, my question, which I'm blanking right now, was, oh dear. Okay. While I'm remembering the question, any comment on...
yeah, I mean, first of all, as a matter of law, you cannot copyright an idea. However, it is, as you just put it, the expression of the idea, the fixing of the work. That's the term that we use. So when the work is fixed, so for example, I guess the best way to think about it is, if you're Paul McCartney and you're walking around the farm in Scotland and you whistle a tune, and that's all it is. It's just whistling to yourself a tune like, Let It Be, let's say. That's not copyrighted. But the minute that he would sit down at the piano and write out the notes, that would be copyrighted. So it's the fixing of the work. So in the case of anyone who's a member of IPNE, driving to the beach someday, you come up with a wonderful idea for a book about a wizard. Well, anyway, hopefully that's not the book you're coming up with. But you see what I mean, too. You can't, I mean, a book about a young wizard who goes through a series of trials in a kind of life and death battle with the forces of evil. That's an idea, and it's not a particularly copyrightable one. But once that wizard has a name, Harry Potter, once the Hogwarts is the school that he attends, etc., 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 those are all things that are indeed copyrightable. And the moment that she would have sat down to sketch out that idea on paper or on her computer, all of that would have been copyrighted.
I see. Okay.
I would like to add something, though, and this is how the courts interpret it. The problem is the courts can't distinguish the expression of an idea from an idea. And what I have found is that in the cases that I've read, what happens is the courts get caught up in looking at the factual issue that is the subject matter that's under discussion, and what they tend to find is that even though it's an expression of an idea, they'll then take that expression of an idea and say that that's the idea itself, and then say it can't be copywritten. So, and this is why I say judges don't understand copyright even themselves. And there have been, well, not enough cases really. Now the question of where the law stands is really up in the air, because there used to be a series of tests that you would go through, like 7 criteria that would define expression, like dialogue, setting, characters, etc., etc. But then the Supreme Court had a case dealing with whether or not a telephone book could actually be copywritten, and that decision threw everything up in the air. So what my contention is that I don't think anybody knows, and the courts aren't necessarily going to protect you. The people who have won have usually been big corporations who have the lawyers who can actually represent their clients' interests. But for the lowly copyright victim, such as myself, there's very little that you can do. So I'm just out there to tell people. I wish someone had told me, years ago, when I was, bright-eyed and bushy-tailed and just so excited and, enthusiastic about getting my work out there. But if you're any good at what you do, I would just say do it yourself. Do it yourself and protect yourself with good people that you trust, who aren't going to steal your work. And if it's good, it'll rise to the top. It will.
Mm-hmm. Okay. Thanks, Ginny. And now, just to finish up quickly, we're running a little bit over time, and thank you both for staying. We really appreciate it. A number of questions have come in associated with general contracting, and so I was wondering if you could both address kind of if there are any pitfalls when drafting a contract between a publisher and an author, and like what to look out for, what an author should look for in a contract with a publisher, most common mistakes, things that are overlooked, what should be put down in a contract, anything like that between authors and illustrators. I know it's a big question, but basically, what kind of advice would you give a new emerging independent author or publisher in regards to contracts in the field of copyright?
Well, it probably would. I would get slapped upside the head by all the attorneys at the Copyright Clearance Center if I even tried to answer that. But because of course the contract is a matter of negotiation. It is an agreement. Contracts really are agreements, right? So we are saying we agree to do this and we agree to do that. Now, sometimes it's a contract for someone to come and mow your lawn. So it's a contract for someone to paint your house, or someone to uh, uh, provide a certain kind of service. In the case of a contract between an author and a publisher, it should be looked at the same way. It's a negotiation. Both sides should be free to ask for what they think is important. And sometimes what does happen, really, on either side, is that everybody wants everything. And that's not a negotiation. You can't wind up with everything unless you're sort of declaring war, and rather than trying to have a negotiation. So what you should think about is what's important to you. What are the rights that you want to reserve to yourself? So, for example, in a contract, it will enumerate the right to publish a book in print and digital form. It will enumerate the right to publish a book as an audio book. It may have other enumerations of various forms of the work. Copyright is not a single right, but a number, actually an innumerable number, if I can put it that way, of individual rights that cover all kinds of uses of a work, as a screenplay, as an opera, as a ballet, whatever it could be, right? So as that negotiation continues, you want to be sure you obtain, if you're the publisher, the rights that you need to exploit. As an author, you want to be sure to retain those rights which you feel are important at a separate negotiation.
Okay, thank you. And Ginny, any comments?
Well, it's so funny you ask, because last night I spent an hour reviewing a contract of a family friend who was about to sign a contract with a big publisher in the music business. And I was actually appalled at how one-sided it was. And I told the young man, I said, look, I'm not going to tell you not to sign it because this is a big break for you, but just understand you're giving everything away. And if you feel that strongly in your potential, just know that you'll have to ride on that because you've just given everything away to the publisher. And what I said to him is, go back to the publisher and say, okay, I see the contract that you gave me. Now let's pretend we're friends, and let's redo this contract. Let's do something fair, because it was not fair whatsoever. And the language was just so convoluted, and I was actually offended. I thought it was just absolutely unconscionable. And these are the contracts that young, desperate people are signing because they want to be big, they want to be famous. He's very young, so can I fault him? Probably not. He's got that youthful exuberance, but down the road, it's going to bite him. So I guess I'm just telling people, if you really think you're big enough for a big company to sign you, or for a big publisher to publish your work, then act like it. Don't give everything away.
Okay, great. Thank you very much to both of you for joining us. Frankly, I've learned so much in the last 45 minutes that I need to go outside for a little walk and absorb a lot of it. And obviously, we're just touching now on the issue of contracts and copyright law. And so if you're both willing, in a future session, we would love to continue this discussion. It seems as though we're just touching on a number of really important issues right now. And so I'd like to thank you both, Christopher Keneally, the Director of Business Development at Copyright Clearance Center, and published author and journalist. I'm going to look into that Escape magazine. It sounds fascinating. And Virginia Towler, IPNE member, practicing attorney, and author of Severed, which is a fascinating novel that examines a number of different themes, one of which is copyright law. So thank you very much for everyone for joining us, and you can both stay on after we cut the broadcast if you have any comments or questions, and so that we can move into a next session, which I hope will take place in the near future, dealing with copyright law. So thank you very much.
Thank you.